And now I'm going to hand over to someone who I expect has a lot of social capital to expend. Someone who's dedicated their life to working in the public interest and to encouraging others to do the same. The Honourable Judge Jonathan Lippman is a former Chief Judge of the New York Court of Appeals, the state's highest court, and is now of counsel in the New York office of Latham and Watkins. He provides strategic counsel to clients on New York law and appellate matters nationwide, and is a leader of the firm's pro bono practice. Judge Lippman's 4-decade-long career in the New York courts included service as Chief Administrative Judge and presiding Justice of the Appellate Division of the Supreme Court. As Chief Judge, he championed equal access to justice in New York and pushed through a requirement for all law students to perform 50 hours of pro bono before being admitted to the bar. He's been described as pushing for justice and fairness and equal treatment as a judge, as opposed to just deciding cases between the parties, leaving behind an altered legal profession in New York because he used his authority to promote an ideal of lawyering as a public service. So we're delighted, Judge Lippman, that you can be here with us today. So please give him a warm welcome.
Thanks, Marianne. Thank you, Marianne, and thank you for inviting me to this great gathering. It's a pleasure to be in Amsterdam at the PillNet conference. It's a pleasure to be with all of you. And so many of my colleagues at Latham are here, and my wife Amy is here too. So I think this is an important place to be. In a couple of days, I'm going to be in Germany talking about the 2016 American election, and this is a much easier assignment to be here today and talk to you about pro bono work and the important work that you all do. Let me say that the fundamental principle of a global bar and a shared international culture that I want to focus on today is access to justice and equal justice for all of our respective populations. Today in the United States and Europe, as well as around the world, we are facing a crisis in access to the courts and our system of justice. Without the benefit of quality legal representation, NGOs seeking social change are unable to effect systemic reforms. And literally millions of human beings are struggling to maintain the necessities of life. They may be refugees and new migrants seeking shelter, or those losing their homes, the roof over their heads, to foreclosure or eviction. Some may be seeking protection from violence by intimate partners, or at risk of losing custody of their children, or struggling to fend off predatory lenders. Still others are seeking protection from imminent environmental dangers or violations of basic human rights. At the same time, funding for civil legal services for the poor in the U.S. has declined dramatically on the federal level, just as it is needed the most. And European governments are imposing austerity budgets that threaten to eviscerate existing legal service programs. In this context, the challenges for me when I was Chief Judge of New York and for my colleagues around the U.S. has been clear. We need to close the justice gap that exists between the desperate need for legal services for the poor and the finite resources that are available. And we need to energize the legal community to live up to the nobility of our profession by increasing pro bono work. In the United States, we have undertaken these efforts in the absence of a constitutional right to counsel in civil cases. We have had a right to counsel in criminal cases for over 50 years, since the 1963 decision of the United States Supreme Court in the seminal case of Gideon versus Wainwright. and the existence of this right requires governments to act and to devote public funding to this purpose. Yet in the civil arena, where the consequence of a lawsuit can be even graver than those of a criminal offense, there is no such federally recognized right. This situation, to be sure, is somewhat different here in Europe, where access to justice is considered a fundamental right. Depending on the circumstances of the case, provision of legal representation may even be required by Article 6 of the European Convention on Human Rights, where the assistance of a lawyer proves indispensable for effective access to the courts. Reflecting the spirit of the convention, many of your country's governments have assumed the duty to provide legal aid to the poor, and government funding for legal services has been far higher here than in the U.S. Nevertheless, Europe, like the United States, must come to grips with constricting government budgets and austere cuts to spending, which is such a cutting-edge issue here on the continent. So like us, you face real challenges to access to justice for all. The UK's legal aid, a model for the world, has been cut dramatically. And some legal aid programs in Europe with low income thresholds and burdensome eligibility requirements can leave many without the help they desperately need. There is more we can do, both lawyers and judges, in the United States and in Europe and around the world, to fill the gap where government funding leaves off. And we can take away ideas and approaches from one another. I believe that steady and substantial government funding for civil legal services is critical to closing the justice gap, and that the U.S. should be closer to Europe's numbers for per capita spending in this area. But in plush times or times of austerity, I submit to you that there is not enough money in the world to provide the necessary legal services. An absolutely critical source of assistance to those in need is the private bar. There is a long tradition of pro bono legal work by the bar in the United States. For us in the States, it is part of what it means to be a lawyer. Historically, lawyers in our country have placed a commitment to public service on a par with their own financial self-interest. While the United States has a well-developed history and culture of pro bono service, the same is not true for most of Europe, even though in ancient and medieval Europe, legal aid was considered a charitable duty. In modern Europe, where the government has assumed the duty to provide legal assistance to the poor, pro bono has not always been an ingrained part of law practice. However, as this European forum testifies to, pro bono work is on the rise in Europe, spreading to European lawyers, not just in U.S. firms with foreign offices, but in European law firms as well. And PILNet has played a significant role in building the emerging pro bono culture of today, and a marked increase in pro bono hours, along with the growing institutionalization of pro bono practice here on the continent. This increase in pro bono work coincides with cuts to government funding, which left a void that fortunately the private bar is helping to fill. Government funding for legal services and pro bono work by the private bar are not mutually exclusive, but rather should proceed along parallel tracks. And that is exactly what I tried to do in New York as chief judge. As the leadership of the judiciary is pivotal to this effort, judges have a unique pulpit with moral authority as the protector of the rule of law and the values of our profession. In New York, I use that moral authority and a values-driven approach to call in the managing partners of all the big firms in the city on a regular basis to seek their support for both public funding for legal services and increased pro bono work by the lawyers in their firms. I received their full and enthusiastic cooperation. Let me be quite direct. The judiciary is not neutral when it comes to equal justice. It is our mission. The age-old ideal of a passive judiciary concentrating on the four corners of its legal papers is a relic of the past. Senior judges must be responsive to the societal issues that come to the doorsteps of the justice system and be proactive in the pursuit of justice. Justice is our business. In New York, I put public funding for legal services in the judiciary budget itself, assigned to all that we in the courts viewed legal services for the poor as essential to the well-being of the courts and the justice system. Public funding of civil legal services went from a few $1 million to $100 million due to the leadership of the judicial branch with the support of the organized bar. These monies are given by the judiciary in grants to civil legal service providers and have generated similar efforts to spark public funding for legal services around the United States. To accomplish this, we made our case in a counterintuitive way, arguing that funding for civil legal services for the poor was not only the right thing to do, but also served the bottom line economic interests of our state economy. We had independent economic studies that showed that public funding for legal services was the best economic investment that the state could make, generating $5 or $6 back to the state for every dollar invested by way of decreased social services and incarceration costs and more money coming into our communities from people whose lives were salvaged by effective legal representation. Leaders of the business, banking, and real estate communities testified to the soundness of this approach and to the positive impact of funding legal services on the economy. New York also led the way in becoming the first state in the nation to require applicants to the bar to complete 50 hours of pro bono service before gaining admission to the legal profession in New York. Building a culture of service in new generations of lawyers, has the potential to change our profession for decades to come. Simply put, aspiring lawyers must embrace the core values of our profession. First and foremost, service to others, or they should not be lawyers at all. And those values should begin to be learned in law school. If we teach aspiring lawyers about contract or property law, we must also require them to learn about values and what being a lawyer is all about. And clinics run by law schools are a great place to start. In addition to new attorneys, we targeted niches within the profession that had been previously untapped in terms of pro bono work. We started an attorney emeritus program for what we call baby boomer attorneys in the U.S. to encourage them to do pro bono work as they get older and begin to slow down their practices. We celebrated them as a model for all lawyers, and we focused on in-house corporate counsel and allowed them to do pro bono work in New York courts whether or not they were admitted to the bar in our state. The goal of these kinds of programs is to increase the army of people doing pro bono work by making it easier and more rewarding to do so. We took a further step in our pro bono efforts by requiring all attorneys to report their hours of pro bono work on their attorney registration forms, providing much needed data to shape our access to justice strategies going forward. However, some in the bar in New York felt that the mandatory reporting of pro bono work and the 50-hour rule for new lawyers before that were a prelude to requiring mandatory pro bono work by all lawyers. This was something that they dreaded, as it would essentially be the imposition of a public service requirement for members of the bar. That was not my intention, but from my point of view, not such a terrible thing. Would it be a terrible idea if every lawyer in New York or in the U.S. or in Europe or around the world gave 50 or 100 hours a year of pro bono work to the poor and the needy? I don't think it would be a terrible thing at all. Ours is truly a noble profession, and pro bono service for those in need is proof of that nobility. I urge judiciaries in the profession, in Europe, and all of you who are committed to the ethos of lawyers giving back to our society, to elevate pro bono work as a core value of the legal profession, honor lawyers for their service, and find ways to facilitate opportunities to do such work for both NGOs and individuals, even to the consternation of a sometimes reluctant bar. Our priority as a profession in the United States and Europe and around the world must be to ensure equal justice and to even the playing field for all litigants. We have a monopoly on the practice of law. We cannot and should not use that exclusive privilege merely to enrich ourselves without recognizing our moral and ethical obligation to the most vulnerable in our societies who need legal assistance. Our commitment to equal justice goes back to the foundations of Western civilization and even to the biblical admonition in the Old Testament to pursue justice. Justice shall you pursue for rich and poor, high and low alike. And if not us, who? We all have the same core values that are certainly not unique to Anglo-American legal traditions. The concept of pro bono publico, working for the public good, is what drives us. Helping others and serving those in need is what makes lawyering truly a form of public service, as it should be. While these lofty goals motivate us, in and of themselves, we have also found that firms derive prestige and much deserved praise for their pro bono work. And they attract lawyers who wish to work for a firm with a strong commitment to pro bono. That was certainly the case for me when I left the bench in New York and I came to Latham and Watkins. I wanted a firm whose value system matched my own. And I think that's what most lawyers want. We want to feel comfortable. We want to understand that what we do with lawyers is not just to make us more wealthy or to have cars and all the wonderful things, and everyone should have that. But being a lawyer is about being a public servant. That's what we do, and that's what really is the bottom line. It is a badge of honor for lawyers to do pro bono work. Pro bono work meets unmet legal needs rather than taking the bread out of any lawyer's mouth. The profession gains in the eyes of society and does no harm whatsoever to the bottom line. However, increased pro bono work and additional funding for legal services is only part of the access to justice puzzle that we must address. We also need new thinking and innovation to succeed, and we can certainly learn from each other in that regard. I would cite just one such example in the U.S. where we borrowed an idea from Europe that has started a new trend in New York and the U.S. Taking the lead from the civic advice bureaus in England, we now use trained non-lawyers to supplement efforts by lawyers to assist the poor and people of modest means with civil legal problems, particularly in housing and consumer credit matters. We took the kernel of the idea from the British system and made our own version of it as a volunteer program by which trained non-lawyers help provide legal assistance both in courthouses and storefronts. This is just one illustration of the kind of innovation and access to justice that is going on in the U.S. to complement public funding and pro bono work by lawyers. We are also, among other new ideas, changing court rules to level the playing field in foreclosure and consumer cases, opening self-help centers to assist self-represented litigants, providing online do-it-yourself legal forms, and finding new uses for technology to help poor people in need of legal help. And the same is true of Europe, with new creative thinking reflected in your pro bono clearinghouses, new law incubators, efforts by lawyers to address the immigration and refugee crisis on the continent, and access to justice initiatives in concert with Goal 16 of the United Nations. The question is, how does all this fit together as we move forward on access to justice here on the continent and in the U.S., still seeing some differences in our legal cultures, and yet continuing to borrow ideas and learning from one another? As I reflect on the ease of movement of lawyers in an increasingly global society, I am again reminded of our common values. With the growth of international law and cross-border legal services, our profession does not stop at state lines or boundaries. Across the board, we should more than ever be as one in our commitment to a culture of service to others. As lawyers, we must avoid narrow, parochial, or self-aggrandizing concerns and focus on the strategies that lie ahead to ensure public fiscal support of legal services, a continuation of the rising tide of pro bono work, and a willingness to think out of the box to achieve our goals. By so doing, we will be able to convey to the public and our governments here and in the U.S. that there needs to be a reprioritization of what is important in our societies. We all need to recognize that legal services and assistance for the most vulnerable among us is as important as schools and hospitals and housing and all the things we hold dear. And our efforts cannot be the exclusive province of young and idealistic lawyers in the United States or Europe or elsewhere, but rather must permeate the entire legal community, from the most senior levels to the newly initiated in the bar, the courts, and the academy. By making this the norm, we can and will ensure that the ideal of equal justice will become the reality in Europe, in the United States, and in our global profession. Thank you so much.